Well, the prosecution in the Frank Smith bribery and extortion case continued efforts today to convince the court that there is a prima facie case against Smith and that the matter should go to trial. However, Fern Carey tells us tonight the defense believes the case should be thrown out.
Focusing on the dispute and the timeline in the case over when former Public Hospitals Authority Chairman Frank Smith and cleaning company owner Barbara Hanna met, lead prosecutor David Jenkins, QC, reiterated that Smith and Hanna met in 2015 prior to the approval of her being awarded a $546,000 contract to clean the critical care block at the Princess Margaret Hospital. He explained that it was at that time that Smith allegedly made a demand for the $5,000 a month payment, to which Hanna asked Smith why he didn't tell her she had to make the payment, as she would have added that amount to the cleaning contract which she had tendered for. According to Jenkins, that evidence shows that the process relating to the awarding of that contract to Hanna was corrupt. The lead prosecutor also informed the court that banking evidence in the case reveals that although Hanna did not pay VAT or NIB, she still had enough money on her account to pay Smith. However, head of the defense team, Keith Knight QC, stressed that the timeline as to when Smith and Hanna met is of paramount importance to the case. He noted that although the prosecution contends Hanna was mistaken as to the date she met Smith, Hanna testified that she met with Smith in March of 2016, and the prosecution cannot now infer that it was in 2015. He also indicated that the Crown did not call on Hanna to clarify the date of that meeting during re-examination. Regarding testimony by Hanna that after Smith allegedly made a demand on her for a payment and she responded, "Why didn't you tell me before so I could put it in the tender?" Knight said as a businesswoman, Hanna knows the tender process, so no reliability can be placed on that statement. The chief magistrate also asked both sides that if the entire case is one of he said, she said, and if the court finds that the prosecution witnesses, in particular Barbara Hanna, is wholly discredited and unreliable, and the court is of the view that a reasonable tribunal could not convict, what is the next step? To which Jenkins responded that the issue of reliability has to be determined at the end of the matter. However, Knight indicated that if the court finds that evidence in the case is manifestly unreliable and discredited by cross-examination, then the court is obligated by law to stop the case. He said if the court rules that the accused has a case to answer and the accused admits to the offense, then on appeal, the appellate court will find that the learned magistrate erred in law in not upholding the no-case submissions, regardless of the admission, and the appellate court will quash that conviction. Now, Frank Smith will learn whether or not he has a case to answer on February 1st. That's when the chief magistrate will rule in the matter. Fern Carey, ZNS Network News.